Okay. All right. So we'll get going. I have a pen for a cursor, so I will try not. Oh, hold on. Here, I can X out of there. There you go. So that won't happen again, but we're just going to have to deal with those X's. All right. So welcome everybody to Legal Queer and A. All right. There we go. So expectations during the meeting. Keep your mic muted. And as always, be kind and respectful. It's an inclusive space for everybody, and especially when we get to the question and answer period, to keep the questions short. There's usually a lot of questions. Today will not be a 3.5 hour marathon question session like the last one, but I will try to get as many questions. And if folks want to stay, I did block off extra time. But so we will talk a little bit about the Pride Plans workshop. And as always, there's an estate planning hack that I go over. And then September 16th is the next legal queer and A. I'm going to talk about in that legal queer and A today, we're going to talk about Chiles v. Salazar. But on the 16th, I'm going to talk about the CHOP subpoena and the subpoena that went out to 24 other medical providers that are providing gender affirming care, asking for lists of their patients along with other medical information and information on their parents. So that subpoena went out to 24 different hospitals, CHOP here in Philadelphia being one of the best in the country. Every institution is dealing with it differently, but we're just going to talk about the effect of a subpoena like that. What could they have to turn over? A lot of parents are reaching out to me concerned. And what can parents do separate from the institution? We're also going to talk about a shadow docket and what a shadow docket is, what that means. It's a Supreme Court secret shadow docket where they decide a lot of very important things, but don't have to publish the opinion, and it doesn't make wide news. And they've been deciding a lot of cases around transgender affirming care, transgender issues generally, all on the shadow docket so that they don't have to have the news and the notoriety around it. So they've been using the shadow docket for decades to deal with cases that they don't want to deal with in the public eye, and then you don't even know what's happening. So we'll go over the shadow docket, what was decided in August, just this past month, as well as in the last few months. And now today we're going to discuss Chiles v. Salazar. We'll talk about a life hack, and then we'll get into your Q&A. All right. So who am I? I'm me. I'm Angela. That's my favorite photo with meeting Edie Windsor. She was actually taller than me, which is a real problem because she was 83. So that does not bode well for how tall I will be at 83. But I opened up my law firm 17 years ago, geared towards the LGBTQ community. And if you would have told me 17 years ago that things would be worse off now than they were then, I would not have believed you. But yeah, before that, I thought I was going to be an international human rights attorney. I worked in human trafficking and lived in Beijing, and then I worked at the War Crimes Tribunal for the Rwandan genocide, and quickly realized after that 2 years being out of the country doing those things that everybody I worked with didn't barely had a soul left. It's very difficult to do human trafficking and genocide all day, every day. Great book, Sex, Drugs, and the United Nations. It's very true. We basically worked from 10 to 2 and then just had to numb out for the rest of the time. So decided, I don't know where I had the wisdom at that age to decide that that's not what I wanted to do, but moved back to the US and realized that one of the biggest human rights, just one of the biggest human rights issues right here in the United States was LGBTQ law. And so I've been doing that ever since. On September 9th at 6:30, I will be hosting a live Pride Plans workshop. So since really the election, but especially since the Kim Davis debacle, as I call it, I have been answering a lot of questions around estate planning in particular. And the biggest I guess, friction point that people have, and it's really the fault of lawyers. I have no lawyer friends. That's why people like me. I'm not your typical lawyer. But the friction point for folks is that it's super overwhelming. You're too busy living. You don't want to be thinking about dying right? And who has the time for that? What are these documents? Why do we need them? So just this macro sort of paralysis by analysis, because estate planning, quote unquote, seems so either complicated, overwhelming, or mysterious. So this is a live workshop meant to demystify that. I will take, in a 2-hour time period, 90 minutes, maybe an hour and a half to 2 hours, I'll take folks through the entire client journey that I take my clients through in a 4 to 6 week time period. So my process is something I've cultivated over time. Again, people are busy living. They don't want to be worrying about dying. So I meet with my folks weekly, right? A lot of estate planning attorneys will give you a whole bunch of homework, fire hose information at you, and then tell you to come back when you're ready, and then you never do. And for the first 7 years of my career, I did the same, and I herded cats for a living. So then I decided I'm not going to let you go. So that if someone avails themselves to the process, we meet weekly, and it's a mandatory 2 meetings on my end that I need. The clarity call is meeting 0. And then after that, meetings 3 or 4 are optional based on you and questions that you may have. 1 woman, 9 meetings, and a therapy break. So whatever floats your boat, same flat fee, but ultimately the goal of the process is we keep meeting until the success loves speed, right? So we keep the cadence going, the momentum going, and we get you done with the process in 4 to 6 weeks. So in this workshop, I will do the clarity call, meeting 0, where I tell folks all about the documents, why they need them, all the things. Then someone will pop up on the screen. Don't know how we will choose said person, but that's Jen's job, who's on this call. And then we will choose that person, and I will do a design meeting with them, and that's where I ask them all the questions that I know I need in order to draft their documents. Then Tom, my co-founder on Pride Plans, will be real-time inputting that information into our Pride Plan software, thereby automatically generating the documents after we're done the design meeting, and then I'll do a draft meeting. So the documents will be ready, and then I will stay with that couple, that person, and go over their documents with them and you, all 9 documents, and explain the legal high level macro. We're not going to go through the documents line by line, but we'll go through them one by one. And then after that, take your questions. So basically the meeting 0, the clarity call, the design meeting, the draft meeting, and then any questions that you have. And so condensing a 4 to 6 week process in 2 hours. And then again, then your questions. So that will be the workshop. You will get a workbook that you can then, as I'm asking the questions of the person, you'll be able to follow along and write down answers for you. So the goal for everybody on the call is by the end of the process, you also went through that clarity call with me by me asking the person that's going to be in the hot seat. You're going to answer those questions for yourself in the workbook, and that all that will be left to do. You'll also understand the questions or the documents because I'll have gone over them with you. And by the end of the call, you know exactly who the people are in your plan, what it all means, and what the estate planning process looks like. And you'll just have to go and actually generate the documents. So, and also on that call, we will be giving away 2 Pride Plan packages, complimentary, thanks to some philanthropic people that have reached out and wanted to help and didn't know how else they could help. So very, very kind. I always say everybody is an ally to somebody. We all have to do our part. And it's been really, really nice to see folks reach out. So we will also be discounting all the Pride Plan packages for 24 hours after that. So one of the other things that I've heard is even though it's Pride Plan specific, is a lot less expensive than working with a private attorney, that it is still out of reach for some folks. And my goal is always that everybody needs these documents. So after the workshop, we'll discount it even more. So, all right, estate planning hack. Where did those go? It's the hospital visitation authorization form. So folks have a lot of questions about these. What is this laminated card and why do we need it? So one of the 1,138 state and federal privileges tied to the institution of marriage. Now, I always delineate, with marriage comes privilege, 1,138 of them. They're financially significant, fiscally advantageous privileges, but they are just that, privileges. There is 0 power inherent in marriage. Only the estate planning documents give you power. And I say that being Canadian because there are only 4 privileges tied to marriage. I come from a long line of straight people that never got married, which is what I think made me a great marriage equality advocate. Because it's just like, why don't you want to let them do that? If they want to do that, it doesn't make sense. And, when there are only 4 privileges tied to something, because after 2 years of cohabitating, you just check a box if you want those privileges. So marriage is truly a religious institution. But one of the 1,138 state and federal privileges tied to marriage is automatic visitation rights to your spouse. But not everybody is married. And as we deal with marriage being on the chopping block, what does that mean for folks? And even if everything were puppies and babies and roses in this country, and Hillary Clinton had won in 2016, and we lived in an alternate universe, one that I choose to spend most of my days, even if that were true, right? You are only considered married in 37 countries out of 195 that fly a flag. So for the last 17 years, even 10 years ago when we got marriage equality, I have continued to treat you statistically, globally, as unmarried, because you are, right? So at the end of the day, on the whole, 37 countries out of 195, chances are you hop on a plane, go do your mini moon or honeymoon or whatever, you're going to end up somewhere where you're not legally married. So this is a contract. This is the one document where I remove a special definition of spouse, which I'll go over with you on the workshop next week. But I came up with a spousal definition that I put in all of my documents post-election, because there was a lot of discourse, a lot of dialogue on, well, if we're not spouses, and I say, my spouse, Angela Giampolo, is my agent, but then spouse, and then we're no longer spouses, do I have to update my documents? Again, 3 years from now, if marriage equality is gone. So it's less of a definition and more of an affirmation explaining why we use the word spouse at this time under the laws in effect in the US, where you are spouses. But this is the one document out of all 9 where I remove that because I don't want to out you by virtue of this card. You could be in a country where it's illegal to be gay, or if you're using these at all, clearly the situation is hostile in some way, shape, or form. So why further that? So it's merely a contract. I, Angela, allow Jen to visit me in a medical or treatment facility. It also gives extra powers. It goes on to say, and that she be given final determination as to all others who wish to visit me, whether or not those people are related to me by blood or by law. So ultimately, which we as LGBTQ folks have a lot of issues with, even blood family, right? So this makes one another the CEO of the hospital rooms. And then there's HIPAA. We love HIPAA. We put her everywhere. Okay, HIPAA's our friend. So in the United States, HIPAA is the law governing the dissemination of your medical information. So you could have all the power in the world and have the healthcare power of attorney, but without HIPAA, they may not then share information. I am not doubting, Clinton, that you are the healthcare power of attorney, but do you have a HIPAA waiver on file? And if the answer is no, straight people don't deal with that, but we do, they sort of get a pass. So very, very, very important. Again, pre-marriage equality, my clients kept this on their person purse wallet. We were married nowhere, right? So person purse wallet. Post-marriage equality, for the last 10 years, it's been passports, right, for those other countries. And then post-Obergefell getting overturned, it'll depend on where you live, right? If you're in Georgia, Florida, it's back on your person purse wallet. In Pennsylvania, where I am, more like glove box, right? I was in Miami a couple of weeks ago. Awesome city. Where is it? Florida. Layover in Hotlanta. Where is that? Georgia. Right? So not quite passport, but a little more top of mind, more like glove box. Okay? So that is the hospital visitation authorization form for your partner and for my polycules and or for folks that just have friends that, rise to the level. We can do however many of these that you want. So, all right. Chiles v. Salazar. Oh, these are the 9 documents. We'll talk about these more next week. Okay, so Chiles v. Salazar is a pending Supreme Court case that hasn't gotten a lot of news, in my opinion. Oral arguments are just a few weeks away. And of course, we expect a decision to be handed down in June. because that's what they like to do, is give us horrible Supreme Court decisions during Pride Month. But this is on Colorado's ban on conversion therapy for minors. And Kaylee Chiles. So ultimately, what is the case about? So the justices will hear a challenge from Chiles, who's a licensed therapist in Colorado, saying that the law banning conversion therapy infringes on her First Amendment rights, and her freedom of speech and freedom of religion. But so she claims that the inability to provide talk therapy to minor children is what's being infringed upon, and that reducing the and declaring unlawful the conduct is one thing, but her speech and her ability to speak to the clients is another, and that her ultimate First Amendment rights to speech are being infringed. So this whole case is professional conduct vis-a-vis professional speech and or freedom of speech. And where is the line between the conduct of conducting therapy, right? You do therapy, you go to therapy, it's an active verb, you engage in therapy, there is conduct there, but then there's also a viewpoint, right? Whether or not you believe in Gestalt therapy, Freudian therapy, conversion therapy, you have a viewpoint on your thoughts of the type of therapy, and then the words literally that come out of your mind, out of your mouth. So that talk therapy is pure speech and not conduct, and should be protected. So Colorado, so Salazar is really just the Colorado state representative. It's not, she's just a political appointee, not anyone in particular, but she has to be the person that defends Colorado in this, but it's really Colorado defending itself, obviously arguing that the law regulates professional conduct, not speech, and therefore is constitutional and not subject to heightened scrutiny. And the reason being is that the conduct itself, for something to be harmful to someone, must engage in some conduct. That the professional consensus is that conversion therapy is harmful to minors. And as we know, numerous medical and mental health organizations, including the American Psychiatric Association, Trevor Project, have all filed amicus briefs supporting Colorado in this, saying that conversion therapy has long been debunked. And it's not even just mental health and LGBTQ organizations that believe this. Since 2012, in the last 13 years, over 1,000 bills sponsored by Republicans have been introduced banning conversion therapy. So truly has been debunked by all as far as just a human, in the world. Research shows that LGBTQ youths who go through conversion therapy commit suicide and attempt suicide 2.5 times more than LGBTQ folks, which is already 6 to 7 times more than the straight and cis folks. So exponential impact on minors, folks that are forced to go through conversion therapy. And now why is this around detainment? So I've been seeing a lot of folks on TikTok and on Instagram saying that this case means that LGBTQ folks very generally could be detained. And so a big reason of my wanting to do this with you guys is to say that that's not what I think this case means, especially for adults, okay? But for minors, a lot of these conversion therapy practices happen in summer camps, like, pray the gay away camps, retreats, things like that. It's not week-to-week talk therapy. It's usually a several week to a month. Sometimes over the summer, they're minors, right? So they go away to these camps, and that's the detainment piece. So I've just seen what I think is some irresponsible content around this case leading to detainment of LGBTQ folks on a macro level, but I 100% fear for LGBTQ youth based on how I think this case is going to turn out. All right. So again, professional conduct versus protected speech, right? So again, unlike the Kim Davis situation where there was zero disagreement amongst the circuits, there is disagreement amongst the circuits here, the 10th and the 11th Circuit. So the Supreme Court does have something that they need, like an issue that they need to be the arbiter, the referee on. And so first and foremost, what is the difference between professional conduct and protected speech? Where is that line and where is the constitutionality of it? And then Chiles, claims that her First Amendment free exercise of speech and religion is being infringed upon. But it's very important to note, even though this won't help us in the long run, that the law explicitly exempts religious ministry professionals. So at the end of the day, if you are a religious institution or ministry professional, you all over the country can engage in conversion therapy practices. All right, so the central arguments of the case, Colorado stating that major medical organizations widely agree that conversion therapy is harmful, that the law is only regulating conduct, what is happening inside of the therapy room, and that states have a right to regulate their licensed professionals, that is the whole point, to protect public health and safety. And exactly that Colorado specifically exempts religious ministry folks. So anyone who wants to exercise their First Amendment right to religion and conversion therapy in that context is in no way impacted by this law. Chiles is saying, obviously the opposite, that she's being censored, and that it's her viewpoint that being gay is wrong, that is being ultimately infringed upon, and so therefore unconstitutional. Also says it infringes on her religious freedom, but I don't see that going anywhere. And then targets talk therapy, that the whole, which it really doesn't target talk therapy, it targets the conduct of. All right, so what does this all mean? So again, oral arguments are October 7th, I believe, and then we'll get the ruling down in June. So if the ban is upheld, meaning good for us, right? The ban is upheld, conversion therapy bad. States will continue, over 20 states currently have these bans. So that's another thing why the Supreme Court is taking this up, because this would be over 20 different state bans that would be impacted by this decision. So states will continue to have the authority to regulate harmful practices as they deem fit and ultimately protect minors. If it's struck down, then Colorado and the other 20 states' ability to regulate people like Chiles will be restricted, and we're going to see a workaround. It's going to be mental gymnastics around a lot of wording of how folks who provide conversion therapy state that they provide conversion therapy. It'll all be about the words, and then it'll be sort of an alphabet ninja exercise. So what I think happens is most likely, in my opinion, that they do a little bit of both. They do what the Supreme Court does and punt, that they will reverse it. In other words, send it back to the courts to do more work, but that they will curb, we don't win, the ban isn't upheld. The ban will be deemed unconstitutional in some way, but a very narrow reversal, and then create some sort of hybrid rule. So what does that mean? That the courts will curb the ban around conversion therapy and make sure that it is not goal and or viewpoint based, that you can ban therapeutic practices that harm folks, but it cannot ban viewpoint based therapeutic practices. And so, what does that mean? And I envision additional litigation to figure out exactly what all that means, where the lines are there. A second potential, less likely, but a broad reversal. Just saying, nope, these bans are unconstitutional, sort of like Roe v. Wade, right? Unconstitutional, and all bans in all 20 states fall. I just don't see that happening, like I don't see us winning. So least likely, a full affirming of the Colorado law saying SCOTUS treats the regulation as professional conduct, regardless of the words used, and upholds Colorado's statute outright. So I just don't see that happening. But again, I see it as a hybrid of the two. So what does that look like exactly? So I view the holding as having two parts. One, first and foremost, that Colorado or any of these 20 other states can't ban conversion therapy based on its conversational goals or viewpoints, right? I want you to go talk to this person because I don't think you're gay. I don't think you're trans. And maybe through talking to this person, you'll have some realizations, right? So that's going to be the focus, is the conversational goal or viewpoint. Part two of the holding, that a state can, in fact, regulate professional conduct that harms minors, even when the conduct is carried out with words, right? So the practical effect is a lot of confusion. What does that mean, right? But the end goal will be that it trims rather the ban that targets the content of the conversation while preserving tools that target how professionals act and the harms that result. All right, so why or how am I coming at this conclusion? Thomas and Alito actually wrote a dissent from denying cert to a particular conversion therapy case. Just widely uncommon, massively uncommon. So Kim Davis filed cert. We're not going to hear boo. If we do hear boo, that's really problematic. But we probably won't hear boo. They're not going to take the case. But Thomas and Alito were so incensed that they weren't able to take the case, that they wanted to grant cert, that they actually wrote an opinion, a dissent opinion, on a particular conversion therapy ban case. And Kavanaugh didn't write a dissent. He's become shockingly very neutral, always pro them, but neutral. Like the Muniz case, he wrote a concurring opinion. I agree with you, but we never should have taken this case. You overstepped. So that's the new Kavanaugh, but I'm liking it. Still, we don't get his vote, but wrote a notation. More common. A notation is more common than a dissent, but still very, very rare, that he would have granted cert. So he went sort of the even keel. And then the dissent, the opinion that they wrote, basically framed talk therapy as protected speech and highlighted that they had a concern around viewpoint therapy, right? That I view that LGBTQ folks are going to hell, and let's talk about that. Whatever it is, right? A viewpoint in therapy. So rare. What happens when a dissent does that, in the very, very rare occurrences that it does that, is it tells the bar, it tells lawyers, right, why this matters down here. It tells lawyers and or activists, the Supreme Court has an interest in it. They just don't have enough votes yet. So let's keep going down this path, because if we keep going down this path, eventually there may be a makeup of the Supreme Court where we will get our 4 votes and then we'll win. We'll get what we want. But it's the Supreme Court signaling to the people that they want to keep bringing petitions and lawsuits and whatnot. So most petitions for cert are denied by a 1-line unsigned order. Just no explanation, just signed. Court receives over 8,000 a year. Between 5 years, 8,000. I went to law school because I don't do math, but 40,000, that's a lot of petitions for cert. 43 dissents were written. 1 was written in this case. They want this case. They're going to do something with this case. Okay, so they're not taking this case just to let a ban be upheld. They're going to do something different than what is currently existing. All right, so what does this mean? Because it's going to happen. So what does this mean for folks? States in these 20 some odd states, all the statutes around these bans will need to be rewritten because they'll be vulnerable around the, they won't, to be redundant, speak to the difference between conduct and speech, right? So the statutes will need to delineate between that, but the bans in and of themselves will all need to be rewritten. We can start by I mean parents and attorney generals who oversee these things, start using existing tools that we didn't have to use for this particular subject: consumer protection, fraud statutes, false advertising laws, child abuse, neglect codes. So there are existing tools that prior to these bans we use to protect folks from conversion therapy, and we're going to have to start reusing those existing tools. There will have to be all the state level Department of Health will have to issue new practice standards and guidelines for therapists about what is protected conduct and what is protected speech. And again, we have thousands and thousands and thousands of literally studies showing that these are harmful effects, but evidence matters. And so if they start going into effect and conversion therapy comes back in limited fashion, then agencies will have to build their case with actual evidence, which they really don't have the manpower to do. But so what does this mean for therapists? What does this mean for providers, ultimately? Counselors can hold sessions that providers describe as exploratory or value, and these are the providers like the Chileses of the world, that they can, it's all in how they're going to frame it: exploratory or values-based. And here's where I'm interested to see how SCOTUS deals with this. Provided the work is patient-led and non-coercive. How does a 7-year-old lead their therapy? Right? How does an 11-year-old, even a 15-year-old, how is that patient-led for a minor and in no way non-coercive if a parent is bringing them to conversion therapy to begin with? Lawyers will be busy protecting them with their new forms, and marketing. Marketing will be the big tripwire for attorney general's offices, how they write it on their website, how it's viewed on their intake packets, trainings that claim efficacy, how they say, "I will fix your child," kind of thing. Like, what is the verbiage that they're using will really be where people who do this type of law get tripped up, or this type of therapy, rather, will get tripped up. So what does it mean for families and kids? Again, like I alluded to earlier, even if the opinion inside the therapy room is about speech and the therapist's viewpoint, did the minor really get there from choice? Or was it pressure? And how will that be dealt with? And then as far as the detainment piece, again, residential programs will become even more popular, in my opinion, just as opposed to the 1-hour talk therapy, sending them. So this ruling won't bless detainment, but it will be read as a cultural and legal permission for the broader project, ultimately, of, not having a choice. And then if a minor is confined or abused, lawyers can still pursue tort claims, false imprisonment, consumer fraud, child welfare, all of the things that they did prior to these bans. All right. And so potential impacts, far reaching, right? Not just on conversion therapy, but on literally the mental health of LGBTQ minors all over the country. 28 states with similar laws will all have to deal with their statutes. And there will be a lot of chaos, a lot of, we call them continuing legal education.
Like, oh, hi, baby.
Oh, um, so we call them continuing legal education courses, but therapists have their version of that. And so there will be a lot of education around, again, what is protected conduct, what is protected speech, where is the line of First Amendment, where does it begin and end, and and then again on the First Amendment itself, redefining the scope of professional speech and how it's treated under the First Amendment. All right, Q&A, and as always, Jen, real quick before we do Q&A, were you going to share the link with me via email?
Oh, I texted it to you.
Oh,
But
did
there's
I
only
say?
one question so far, which is from CC and Amy about we have all the other forms in place except for the one that you were talking about with the hospital visitation. Is there a place where we can
uh,
find language that you used for that form?
um, not exactly. I kind of made it up, but um, in 17 years, it's gotten two couples their final 5 minutes with one another, and folks have used it in a variety of other settings. If you email me, we can, just email me. We'll figure something out on that one in particular.
Thank you.
You're welcome. All right, and so just the question can be about anything, Chiles v. Salazar, or whatever you have going on, whatever question, marriage equality, anything. Let's see. I work at a counseling practice in Washington focused on queer neurodivergent clients. We see a lot of youth. How can we protect our clients as so? I too have a lot of clients that have therapeutic practices that focus on either gender affirming care or LGBTQ folks generally. And I kind of view this as a lemons and a lemonade situation, right? So in states where gender affirming care will still be permitted, a lot of my therapy clients who own therapeutic practices were worried about whether or not they were going to, basically get criminally charged for providing gender affirming therapy, talk therapy. But if it is talk therapy, and what this case is saying is that viewpoint therapy is protected speech, then if your therapist's viewpoint is that you transitioning is in your best interest, then the same thing applies, right, to us and LGBTQ focused therapeutic practices. So I see this as a huge lemon into lemonade for that. I was talking to counselors and therapists at clinics that provide gender affirming care just a few months ago, saying a very different thing, because the federal Health and Human Services is saying anyone who provides it was specific to medical providers, but the federal statute defines medical providers very broadly and haphazardly. And so all throughout all the federal definitions of medical provider, there are several instances that I found where that includes therapists. So if the Department of HHS, Health and Human Services, is saying gender affirming care, medical providers of gender affirming care will be held criminally liable, then an argument could be made based on the hodgepodge way that therapists are looped in some instances, but not others, that therapists would also be criminally liable. And so I was advising, and I still am, that therapeutic practices redo your website a bit. Like don't give anybody a reason to be on the radar. Like, this isn't the time to fall on a sword. If the government's going to say you're criminally liable for, like, they're not going to decide that they're wrong. you will lose that. They're going to make a case out of you and all of the things. So, how can we still make it clear what the services that you're providing, and be somewhat safe so that you're not handpicked and or targeted, right? So, but as far as what happens in the room and the therapy that gender affirming therapists are providing, if this case gets decided the way that I think, then that's our holding for why and how we can do what we can do. As far as protecting, the youth themselves, that's why I'm going to follow this one up with the CHOP case. Why does the government want a list? Why do they want the list of minors? Why do they want the names of the patients? If they want to simply know which of the institutions are providing gender affirming care in order to cut off federal funds, then that's one thing. They'll answer that subpoena and say, we do provide gender affirming care. And then, unfortunately, University of Pennsylvania and these 23 other institutions would lose federal funding. But the subpoena is so broad. They want lists. They want the names of all of the minors that they've ever treated and their parents and information on the parents. Now, why would they want that? Right? And that, it gives me chills, the tragic foreshadowing of this list building, right? I forget which crazy MAGA politician just posted on X about the shooter, the school shooter that was trans, and that all trans folks need to be, rounded up and detained and studied because they're sick and evil. And, this is an elected official saying this as of yesterday or today. So, HIPAA, make sure that if there was a subpoena directed at you, Sydney, how would you be able to answer it strongly, confidently, that you don't have to give up that information? Because that is ultimately what they would want, is the information. And again, we'll have more information if that Department of Health and Human Services, ban on gender affirming care does in fact impact therapists. All right. Revocable trust question. If we jointly own property, should the house go in? And what is that process? House is paid for. Even if it weren't paid for, even if it had a mortgage, I love when I talk to folks and I was like, do you own a home? And they're like, well, we don't own it. And I'm like, just because you own it as much as an American can. Okay. So very rare that we actually pay off the mortgage. So good job, CJ, on that. But even if there was a mortgage, yes, you can transfer a home into, Zoom has made me very prop focused. This is your revocable living trust, and this is your home. Okay, so in the water are all of your assets, everything else. All right, and this revocable trust is your probate avoidance tool. Everything that's in here, the water, automatically avoids probate. That is the whole point of a revocable trust. It is merely a probate avoidance tool. All right, now what is probate? Why does it suck, and why do we want to avoid it? Come next week. It's a little bit longer of an explanation, but I will explain why we all want to avoid that. So the only way for real estate in this country to avoid the probate process is if it's in a joint or solo revocable living trust, because it does not have a beneficiary designation. It has a deed. It has title. So there's no way for businesses, the two most common assets that Americans own that pull them back into the probate process unknowingly, is real estate and businesses. If all you owned were 401k, stock bonds, life insurance, brokerage accounts, things with penny forms, you could successfully avoid the probate process. All right, real estate is our most common asset. So we retitle it. Now, yes, you own it jointly, right? One of the 1,138 state and federal privileges tied to the institution of marriage is, because the government knows probate sucks, they created it, right? They know it sucks, is automatic probate avoidance upon the first of you to die. So for every legally married couple, if you did no planning whatsoever, not even one document, not the will, not the trust, nothing. If you did nothing, okay, and Angela dies, probate avoidance to spouse. They figure you've accumulated everything together. Why should you have to give everything that you've accumulated in your life to your spouse through the probate process? So you get one freebie with marriage. Then they assume the survivor is old, has lived a long natural life, has everything that they already had, plus what they inherited from me, and will get her in probate then. Okay, so this was created for folks who wanted double probate avoidance. The one freebie with death, or with marriage rather, wasn't enough. We want double probate avoidance. So Angela dies, the freebie to the spouse, which CJ is your situation, but then the survivor at 91 doesn't need to do anything, and there's automatic probate avoidance. Seamless administration of everything you've owned in your life. And then at death of the survivor, this becomes irrevocable. So this is merely a probate avoidance tool. No creditor protection, no asset protection, no tax sheltering. You don't even see the benefit of this in your life. Both of you have to be gone for you to pass on your assets outside of probate to your intended beneficiaries. What is the process? Retitling of the home. We do it for our clients. We handle businesses and real estate. And then I work with your financial advisor around all the other assets. Only you can handle bank accounts, but you can also use a title company. Okay. So there is not going to be here. There's not going to, the SCOTUS won't hear Kim Davis. Is that correct? I don't know, for sure. I don't have a crystal ball. I think it's a very weak case. That was a 3.5-hour legal Q&A that I did. That recording is on YouTube. And we're also gonna splice it up into more digestible snippets for folks, like, because some of the Q&A itself, I answered over 10 pages worth of questions. So the questions most frequently asked will provide snippets, but the Kim Davis case is weak. If the Supreme Court wants to take down marriage equality, there's better ways to do it. So no, I don't think that they will hear her case. If they do, like I said, we are in trouble, because that means they really want to overturn marriage equality, because it's not a great case to do it. How would APA and licensure guidelines be addressed? They're all going to have to be revised. The state will have to issue new guidelines and licensure guidelines, all of the things, just like the statutes would have to be revised. So would the guidelines, and they would need to be issued in light of the holding. So like when the tax code has an update, it takes accountants a minute to really read through the changes in the tax code and then advise accordingly. So until the holding actually comes down, again, these are my sort of, rainbow crystal ball hypotheses based on my legal analysis. It's in no way, 100% accurate. So once the holding comes down and we know exactly what we're dealing with, then folks will issue guidelines accordingly. It's important to get married. Should we get married before the 9 docs? How important to have the same last name on marriage license for future legal needs? So, I treat all of my clients as legally unmarried, because again, statistically, you are in this world. 37 countries out of 195. I had a client call me. They were in the Turks and Caicos, legally married for 10 years, and a woman passed away on a scuba diving accident and succumbed to her injuries. And for 3 days, her wife, partner of 23 years, wife of 10, could not gain access to her. And then nobody would talk to her about the legal documents to medically transport the body back to Maryland. Legal closest next of kin was her sister in Wyoming, who then flew in, signed the legal documents to medically transport the body back to Baltimore. Then when the body arrived in Baltimore, her status as wife kicked back in. So that story involves 2 of the 9 documents, this one and the agent for disposition of remains. So again, you could be married together 47 years and married for 10, as long as we've had marriage equality, not married in the Turks and Caicos, right? So I treat everyone as though you're unmarried. So whether you're married or not, yesterday was the time to have the estate planning documents done. Where can we access? So all recordings moving forward on YouTube. I feel like that's the easiest place. Anybody can go, and then you can share more easily instead of just emailing you a link. At Your Gay Lawyer is the handle, but I'm sure if you just put my name in the search of YouTube, the channel will come up. But everything that I do content-wise will now live in that one place. So whether you follow me on TikTok or you follow me on Instagram or you're off social media and you choose this, which is why I've created this space, it won't matter. Everything will be on YouTube that I create for folks. Yes. Do you foresee our right to adopt being reversed if our right to marry is? Yes. So that was the whole that's my analysis of marriage equality, is that there will not be one big overturning of Obergefell, that it'll be an erosion of Obergefell. We will have our rights, the 1,138 state and federal rights tied to the institution of marriage, death by 1,000 cuts, they will be slowly eroded. And it's already started June of 2024. Okay, so going on 15, 16 months ago, the Department of State v. Muniz, Supreme Court issued an opinion in that case around a straight married couple immigration case. This is the one where Neil Gorsuch said, wow, you went above and beyond. We should never have taken this case, but somehow you found a way to make it about marriage equality. And the dissent said all the same things. How did you make this an immigration case with a straight couple about marriage equality? But they did, because the Supreme Court has to have precedent, other Supreme Court precedent, a case that they can hang their hat on to overturn something. And up until June of last year, they had nothing. We only had really good cases around marriage equality, thanks to Justice Kennedy. So now that the Muniz case will be cited moving forward for the removal of the rights inherent in marriage. That particular right, Amy Coney Barrett wrote the opinion, and she said, the Supreme Court held that, yes, you are absolutely right. Everybody has the fundamental right to marry in this country. That does not mean that you have the fundamental right to cohabitate with your spouse. What that even means, I don't know. A lot of folks don't realize that she adopted her 4 children from around the world. And wouldn't it stand to reason that, okay, we all have the fundamental right to parent, but not cohabitate with our children, right? She wouldn't agree with that, but somehow you can take away. So what Obergefell did, and literally the holding said, is that all the rights inherent in marriage are a bundle. And that was the first swipe at marriage equality, saying it is not a bundle. We can remove, you may have the fundamental right to marry, but not dictate who marries you, i.e. Kim Davis. You may have the fundamental right to marry, but that doesn't mean you get the right to adopt and have children, or have the right to create children through IUI, IVF, or surrogacy, and on and on and on, right? So that's exactly how I view. So it's not that marriage equality will be reversed and therefore we'll automatically lose our right to adopt. I feel like that will be for religious exemption reasons. In certain states, they will say, yeah, you're married here in Texas. We're not saying you're not married, but you don't get to adopt. We don't believe that. So I just view the decoupling of those 1,138 state and federal rights. I have a question regarding my marriage certificate. I'm married and would like to update the certificate to reflect my correct legal name. All of my documents have been updated. Was married in Nevada, but now live in California. So this is an unfortunate one that I deal with a lot. So you were married in Nevada. So it'll be a Nevada question on whether or not you can update the marriage certificate. Not all states allow, and or counties, it's not even a state thing. It would literally be the human in the county, but you may not be able to update the marriage certificate. And so if that is the case, I have had folks get remarried. Now, I don't recommend that for a couple of reasons. One, the rights inherent in marriage accrue based on how long you've been married. So Social Security survivor benefits, 10 years, right? And a lot of the other ones have time associated, so you'd be starting over the clock. And then the other reason is at the end of the day, the marriage certificate itself, it would be amended. There would be an amendment there. They would be able to find out. Well, and the other reason is you'd have to lie on another government form. So marriage licenses, when you fill that out, asks, have you been married previously? If you answer yes, then they expect that a divorce decree will be handed over next. And then you don't have that because you're trying to get married again, but under a different name. One, you know, so it's a very difficult individual, person by person, your threshold for safety, the benefits associated, the dangers around filling out the form incorrectly. So if you reach out to me, individually, Corey, we can talk, more in depth about it and options for you. But again, first and foremost, the checking with Nevada would be key to see if it's an easy fix. California, I do have folks in the midst in California. They're updating it, but California, is California. They're awesome. So, all right. My daughter is being asked to only use the nurse's bathroom under code as well. Students must be allowed to use the facilities consistent with their gender identity. And if this, I am now being asked to talk to the superintendent. Any guidance? Well, sounds like you have the law, figured out on your side. As far as guidance, I would say make it very matter of fact. Non-emotional, matter of fact. Again, I just got done saying to Corey, that in California is awesome and all of the things. Without knowing more about the school and sort of the personal context, I don't really have guidance, but with any of these, who is being, where that directive is coming from, I'd be curious, right? You're being asked to talk with the superintendent, who's issuing the directive. Are they different, or are you talking to the person who is issuing this directive? So, it's all about the end goal and ultimately protecting your child and making school a safe place, and however that conversation needs to go with that, in mind. But it sounds like you're ready for it, as far as the information goes. Colorado, parent here due to recent school shooting. I'm worried about my adult son's name and gender change pleadings being discoverable. Yes, absolutely move to have the record sealed. I do that for all of my clients. We seal everything because, again, even passport changes, there's a code that they use around, if there's been an amendment to a passport, right? So, and that's what trans folks are worried about is like, okay, so everything matches, right? But then if they really dig deep and look for those codes, oh, this was amended. What was it amended for? Gender identity and, and sex, marker and name. And so then that identifies the person as trans. So anything that we can get under seal, absolutely. Based on a car insurance renewal, appears that the old name and when someone transitions after the age of 18, it's just hard, right? You reach that age of adulthood, credit cards, car, all of the things that if there are any parents listening, to the extent that you, and not all trans folks, knew when they were before the age of 18, but for parents who have the ability to get all of this done before their child turns 18, then a lot less is sort of like concretized out there in the ether in that dead name. Can't recall which social site I found the address or link to get on your list to receive prideplans.com. And I think maybe Jen may be emailing or like messaging you guys privately. I'm not sure, but prideplans.com. If you go there, there's a newsletter, subscription, and then anything we do will go out to that list. So it's not necessarily about the Pride Plans workshop, but it's just a central place for email for us to send out whatever it is that I'm doing. And then obviously social. I am on a board for local LGBTQ youth center that supports queer and trans youth, some of which come from broken homes and may not or don't have supportive parents and guardians. Are there resources for staff that I could share with them for cases where youth may need support, where so I'm on a board for a local youth center. Okay. Yeah, maybe a loaded question. Yeah, so my questions are, first and foremost, what state? I want you to be careful. It doesn't sound like you're associated with the school. So even if you're in a red state, you're not a guidance counselor, right? So again, it's just about knowing what the laws are. I have so many teachers in red states that have contacted me that have quit because they can't in good conscience do their job and not be supportive and helpful to LGBTQ youth and worry about being charged with child abuse and all of the other crazy things that they're in danger of being charged with. So as if there's a youth center, you are that youth center, I believe. So like for us locally, it's the William Way Center. So as long as it is a nonprofit, this is the mission, the charter is to help LGBTQ youth. Then are there resources, support for staff that I could share with the staff, at least guide them in the right direction? I can put together something based on, again, this is June of next year, so it's not happening right away. And then I may be wrong, right? I don't think I am based on the dissents that Thomas and Alito. But again, I have no clue how they're actually going to write the opinion. With all that said, macro, even if it weren't about this case, I can write. I'll create a sort of FAQ for. Let's write this down. A resource for staff / adults to help youth facing potential conversion therapy. Okay. Oh yeah, so Jen, there you go. Yes, Jenny, I say that in almost all of my meetings. I am not an alarmist, and I am a lemons into lemonade kind of gal. I am super, I'm by no means an alarmist is all I can say, but these are alarming times. That's just very well said. A few times you've referenced Georgia as a state you need a heightened awareness of. Just because I say the same things over and over. Nothing about Georgia. I lived in Atlanta, so I have a connection to it. And I lived in Florida, so I use Florida and Georgia a lot just because they're sort of right here. I used to use Alabama a lot. There was one seminar where I used Alabama like 10 times, then I apologized to all Alabamians out there. All right. Yeah, a lot of people are hopping off. Jen, do you have all of these questions captured already?
I do.
Okay. So if anyone has any other questions, if you want to throw them in the chat now so that Jen can capture them, and then I will answer them either in a video, probably one long, not long, yeah, long video, or maybe individual videos. I don't know. It'll depend. And so again, Pride plans next Tuesday night, 6:30 p.m., not at noon. So that workshop, I've also had a lot of folks with this Pride plans, or with this legal queer and A say they work and it's hard. And so purposefully, we made that one in the evening. And so that's at 6:30 next week. Register for that, link in bio and any of my socials and in the, hey, Andy. So yeah, on the 16th, I'll be talking all about CHOP. I'll talk all about CHOP at the next Queer Nay on the 16th, along with the shadow docket. All right. So big hugs to all of you. As always, the energy is amazing. The questions are awesome. I feel the support that everyone has for one another. So thank you for showing up. I'll continue to show up. I'll see you next week if I'm going to see you on Tuesday night. And then if not, 2 weeks from now, same time, same place. And we'll talk soon. Bye, guys.